Another one of our webinar, Dr. Francesca Bartlett from the University of Queensland. Can I begin the session by acknowledging the traditional custodians of the lands on which we're I'm on the land of the Wurundjeri people of the Kulin Nation. Fran is in Brisbane on the land of the Turrbal people. We acknowledge the Turrbal and Yagara people, the custodians of the land of the area we now call Brisbane. There are people tuning in from across the country. We've got about 50, I think, online at the moment. So we acknowledge that we all live and work on Aboriginal land. A couple of housekeeping things from me before I hand over to Fran for a really important conversation about confidentiality in legal practice. Hoping to make a recording of this available, and we'll distribute that around to people. You should also have received a copy of the PowerPoint slides just in the last little while, and we'll also try and distribute those after the session. If you've got questions to ask while we're going, feel free to do that. You can ask a question by typing a question into the questions box, or you can press that button that looks like a hand on your GoToWebinar control panel. We'll see something that looks like a hand going up at our end. We'll be able to unmute your microphone and you'll be able to ask a question directly. Feel free to chip in with questions or with examples of some of the things that we're talking about, which I think will make this a really even more useful conversation if we can have some practical examples of how these issues are presenting in community legal centres. As my housekeeping things, can I hand over to Dr. Francesca Bartlett, who is from the School of Law, the Beirne School of Law at the University of Queensland, and has done a whole heap of research and teaching in the areas of professional responsibility, and is really well qualified to talk about the legislative framework and the common law, the duties that we owe our clients in community legal centres to keep their information. Fran, thanks very much. Over to you.
James, thank you for the invitation. Hello from the law school that I'm sitting in. I am assured by James that it's okay. Apologies to those if there's a mismatch, certainly in terms of section numbers that I've put up, ethical rules, that is the Australian Solicitor Conduct Rules, or perhaps the barristers' rules. There's a little bit of difference around the country, so apologies for that. I will point out one issue that I know about that's different. I'm hoping that you can follow my PowerPoints as I click through them, but I understand that sometimes there's a bit of a time lag, so apologies, and I will kind of indicate that I've gone to the next slide as I'm speaking. I thought that I would begin, given the very limited time I have, on really an incredibly expansive topic, potentially, with lots of long arms of issues into our professional practice. To start with, carving off all the things I can't talk about in the time if you're interested and they come up in your professional practice. Just would like to do in the future in terms of a research collaboration too. I would be really interested to hear if there are some really big professional practice issues that are coming up. You would like to work with me and other academics. It's a big issue in the community sector that needs much more research attention. Okay, so let me begin, as I said, by carving off some issues. I am not going to all of those voluminous case law about privilege, but you know, it's a really interesting issue that gets lots and lots of judicial attention. And it comes up particularly also in terms of that idea of for example, a recent decision in Queensland, excuse me, about excuse me, entered in or certified in the country, whether they could provide advice that was covered by privilege. seems to me that maybe in the community sector this issue might come up a little bit in terms of other people that we work with providing sort of quasi-legal advice that's overseen by a lawyer, that might have privilege issues that we could investigate. But as I said, I just can't go there to talk about all the nuances of legal professional privilege. So I'm understanding my mandate as really mostly talking about the ethical obligations, which means that I'm talking about confidentiality because that's what the ethics rules refer to, but obviously that will encompass things that are subject to privilege as well. You know, the old dicta that I'm sure you've all seen before from those big cases which relate to claims of privilege, about why it is that we are so confidences, and that is obviously in relation to justice requires us to have all the information that the client. It is an important, very strongly recognised and protected at common law. So it's the justice underlying it that drives us. There are a whole range of sources at law of that make, and I can't talk about all of them as a matter of the lawyer-client relationship. Of course, it arises by nature of us being in a contract with the client, and that might be expressly in the contract, but of course in many situations, possibly in the community sector in particular, we might not have written contracts with the clients because we're not obliged to under the Legal Profession Act or the Uniform Law or similar acts that apply if, for example, we're providing free legal work. But of course there will be an oral contract that arises between us, and it will be implied into the contract that you would keep the client's confidentiality. It's a fiduciary relationship too, and that sort of core nub of the fiduciary relationship is this idea of trust and loyalty, and one manifestation of that is that we don't breach that trust by telling the client secrets. But mostly what I want to talk to you about, of course, is the clear ethical governance of that comes through ethical rules. As a sort of a illustration of what I was talking about in terms of the difficulty of talking nationally, the ethical rules have different legal status. So here in Queensland, they're not laws. I mean, they function, of course, the same way because most lawyers, unless they're government lawyers, are obliged to be certified by the Law Society, and therefore it binds us. But in New South Wales and Victoria, they are actually law under the Uniform Law. So slightly different legal status, but of course they have a very similar kind of result for us in terms of us being able to practice law lawfully. Of course, there are lots of common law definitions of what is confidential information. So, for example, from tort law, a breach of confidence is considered very broadly that kind of reasonable person test associated with what they would expect to be held confidential when it's provided in a confidential context. So medical records, for example, would clearly be expected to be kept confidential. And I just raise it here because, you know, obviously, again, that might pertain to non-lawyers who are working sort of around our legal practice. They might have duties of confidence because of the nature of the way that it's been communicated and what's been communicated. As I said, I'm not going to say any more specifically about legal professional privilege, but of course we have to be careful of non-lawyers providing legal advice. Now, there is another difference around the country in relation to the common law, and here I'm talking about the voluminous case law about former clients seeking to enjoin lawyers from acting for a new person because that lawyer knows something about them which will be misused, so a breach of their confidence. I'm not going to talk about all that case law because there's just too much of it. I will touch on it a little bit. But what's really different around the country, or certainly as between Victoria, say, and the rest of the country, is that in Victoria there is not only a continuing duty of confidentiality, but potentially also a duty of loyalty that persists after the retainer has finished. So that might be a source of an injunction against, or seeking an injunction against a lawyer. In Queensland, we say that's not the case. There's no continuing duty of loyalty, but there is a duty to keep the client's confidences beyond the end of the retainer. I'll come back to that point in a minute. The reason I raise it here is that is in the world of that the sort of inherent jurisdiction of courts to keep the keep the common law and keep the administration of justice. But there's another place where I think we can say perhaps the law is the same around the country, and that's in relation again to this strange law jurisdiction of professional ethics. So I've got on the slide an old case from Western Australia, Fordham and Legal Practitioners Complaints Committee, but it's a really interesting case of where a couple of ultimately High Court judges have said maybe there's a different threshold as between all those conflict cases that we know about and professional ethics, and bottom line is professional ethics might be a higher bar. So a sort of a sense of duty, continued duty to that may continue on past the retainer even in jurisdictions like Queensland. So let me give you the context because I think it really, really matters here. It was a lawyer who was acting for a man who was charged with unlicensed firearm, possession of an unlicensed firearm. The reason why he said he had it was because he was afraid for his safety because he had been previously kidnapped. Now, the difficulty for the lawyer is that she had actually represented the accused in that kidnapping. And so she had got information in that former relationship for that defendant about the nature of the finances of the man he kidnapped and various other sort of matters. Then she gets briefed to represent the kidnappee on an unlicensed firearm charge, and there is an objection to a breach of confidentiality in relation to the former client. She says, no, look, this isn't really a problem because the information that I obtained in that former client relationship actually is in the public realm. So that all ended up being kind of in public evidence. I have no continuing duty of loyalty, there's no problems. But this was a discipline complaint. This is in the ethics jurisprudence, and ultimately the Western Australian Tribunal said, well, no, the context matters here because it was only a couple of weeks after she'd represented her previous client only a couple of weeks before, and put her former client on the stand and cross-examined him about information that she probably received in the course of that former relationship. Now, it was no longer confidential, but that was enough to commit an ethical wrongdoing. So they talked about this idea of not adopting a position hostile to a former client as being a professional wrong. As I said, ultimately it ended up being an appeal to the High Court, not granted, but she came before Justices Kirby and Gaudron, and Kirby, in his way of speaking, said that this was a sort of a no-brainer, that this was the sort of thing that lawyers know in their bones not to do. And so ultimately her appeal was not granted. So we have to be careful of these sorts of situations. Perhaps confidentiality, that we can't misuse information that is going to be hostile to that former client. But perhaps it's a very unique situation that she was facing. Okay, let me go to slightly more solid ground. The next slide is, of course, Rule 9, which is the ethical obligation to keep client confidences. The important thing in this rule is that it's very much in reference to the relationship of lawyer-client. So we're only looking at confidential information that is disclosed to the solicitor during that engagement. but of course the bubble is widened by those subsections to allow the lawyer to permissibly, ethically, for example, speak to other lawyers in their practice. I'll come back to that issue in a minute. Okay, so what is confidential information? The first dot point that I have on this slide is taken a case. It describes it as all information about his, and I've gender neutralised it, and or her affairs to the client learnt directly or indirectly in the course of professional relationship. So, you know, the sort of fairly obvious definition you would expect. But we have to be pretty open-minded about this, and I've tried to think about how this might be relevant, particularly to people in community practice. We might be servicing clients and other clients that are sort of in their close community. There is a really wide definition of what we mean by confidential information from the disciplinary case law, and I've given you the example here of Legal Practitioners Complaints Committee and Trowell. This is one of two cases I'm going to give you in relation to the Schapelle Corby saga. Lawyers seem to have real issues ethically associated with her representation. Now, this lawyer made public statements associated with the defence of Schapelle Corby in Indonesia, specifically in relation to a suggestion that there be a bribe paid to a foreign judge. And one of the arguments that that lawyer made was, well, I'm not really in a relationship with Schapelle Corby, I'm in a relationship with her sister who's giving me instructions, and I've got information about her, but it's very sort of attenuated the way that I've got. And the tribunal said, well, it's not just sort of information that you learn from the client when you're in a sort of direct client conference with them. It could, for example, be information that you would learn, you would never learn but for having been in a lawyer-client relationship, for example. And that sort of widens the bubble quite a lot, I think. Also, of course, we have to be aware that it might be information we received before the start of the actual contractual relationship. So information that was sort of preliminary to that will also fall within that ethical bubble. And of course, any other sort of opinions that are sought in relation to the client's matter will also be covered there as well. Now, another definition of confidential information that I think is relevant here are a number of cases, and these are injunction cases, where the confidential information has about the sort of materiality of the matters, where the lawyer has acted for, say, the couple in a finance situation, providing advice about a debt matter or something, and then later on is asked by one of them to act in a family court proceeding in an end of a marriage situation. The information that the lawyer might have had in that former client relationship may not be terribly relevant to the financial affairs of marriage or something. Maybe it is, and then we clearly do have a problem. But it might be an impression of the former client that might be enough for there to be a concern about whether the lawyer acts or not. And so that fills in this idea of what's a confidential information. So what I mean is what the lawyer infers about that client. So I'm quoting from what Justice Gillard said in that case. In this regard, the nature of the relationship between solicitor and client might be such that the solicitor learns a great deal about his client, his strengths, his weaknesses, his honesty or lack thereof, his reaction to crisis, pressure or tension, his attitude to litigation and settling cases, and his tactics. These are factors which I would call the getting to know you factors. The overall opinion formed by a solicitor of his client as a result of his conduct may, in the circumstances, amount to confidential information that should not be disclosed or used against that client. So it's quite a broad definition that we need to keep in mind. Okay, so on to the next slide. It's a very straightforward point, of course, whose confidentiality is it? As with legal professional privilege, it's the client's. Of course, you need to be careful to ascertain exactly who the client is. That would arise particularly, say, in that as representing a company. That might be the company, the director who's been giving you instructions and so on. As I said before, the client may be a future client that then turns into a present client. And I note here completeness that giving information in one retainer, that information that information isn't only information from your client. That is in the glossary of the Australian Solicitors Conduct Rules defined very broadly as information that, for example, you might receive from the other side and cannot be used in a later matter. So I'm referring here to Rule 10, which is the associated conflicts arising as between a current and former client. As I said, I can't get to a lot of the law associated with conflicts, but I'm happy to come back and talk about that if you're interested in more detail. But while a related point that I think perhaps a lot of lawyers aren't necessarily attuned to, which is receiving information in a court process or any kind of adjudicative process that's compelled from the other side. So the lawyer receives documents in a disclosure or discovery process, or perhaps it's from an Antoine Pillar award, or even witness statements and so on that haven't been adduced in evidence. Was made an implied undertaking to the court not to use that for a collateral purpose. There is a discipline case in Queensland of LSC and Cochrane where the lawyer's done precisely that. So he was engaged in divorce proceedings with his wife, and as part of that there were some subpoenaed documents from a government department in relation to her father, which included some medical records. A year later, Mr. Cochrane, the defendant lawyer, made an application under the Justice's Examination Order, which is now the Emergency Examination Authorities, I think, in Queensland, which are whereby you can ask a JP to authorise a medical examination of somebody. But the point was that he used information he had received under compellable processes to do something else later on, and that was a clear breach of what was found to be contempt of court. He pleaded ignorance in the discipline tribunal, and the tribunal said, and I quote, to act as he did in ignorance of a significant and by no means obscure principle of law involved a departure from the standards to be expected of a solicitor of ordinary competence, and it was unsatisfactory professional conduct to do so. Okay, so let me move back a little bit to something I just quickly mentioned, but is of course a real issue where we have in particular clients who not only are former clients, but for example might have passed away. So there's nothing actually in the ASCR that defines this, but I think it's implied in Rule 10 that we are keeping confidences beyond the retainer, and indeed they may persist beyond the death of the client. If you move to the next slide, this is particularly difficult where, as I said, the client has deceased. The question then is, to whom do we owe that confidence? And the answer is to the personal representative or the successor in title of the deceased. Only they can waive or authorise us to use that confidential information. Now, one of the scenarios that was raised by one of the registrants of this webinar was a really curly, difficult one, which immediately I thought was in relation to a lawyer who had sort of drafted a will for a husband, and there was some issues associated with his financial solvency. Wasn't sure if the wife was aware of it, and then after his death the wife seeks advice. Now, if the wife is the successor in title, then I don't think we've got any confidentiality problems, because she's entitled to be told the things that the lawyer knows about the deceased instructions. However, of course, if she's just, say, a beneficiary, then the lawyer may well have a difficulty there. The lawyer might have a conflict because in acting properly and competently for a client, we always have to tell the client everything that we know that's going to relate to their matter and provide them fulsome legal advice. Now, I've just reread the problem that was sent through, and my understanding is that perhaps what the difficulty was in that scenario was, in fact, that the husband had received some financial sort of advice with his financial distress, which perhaps the wife didn't know about, and then after his death the wife has come for advice about winding up his estate. In that case, I think that there is a conflict problem, probably because that advice was provided in a very different context. But if it's about financial affairs, then that's obviously going to be very germane to advising the wife about the estate. Having said that, I have sent along with the PowerPoints a non-binding ethics ruling by the Queensland Law Society. It's slightly different issue, but it might be interesting to have a look at for any of you who are encountering these kinds of problems. If all that is required of the law firm is to sort of assist the client to execute the estate, then there may not be, this conflict may not arise. But I think that it will really depend on the nature of the facts in detail. So I probably can't really resolve that issue, I'm afraid. But can I say at this point, and I will come back to it, that there is a very clear exception to Rule 9 which allows a lawyer to go and seek advice about ethics, and it's a really good practice to do so. And one of the things that a lawyer can do for a really curly question is to seek one of these kind of ethics rulings, which are available in Queensland. They've been done in Victoria for a long time and may be available around the country. So seeking some more advice about it in terms of more details about that matter might be a good idea. I wanted to add here that in relation to contested probate, there are lots of difficulties associated with lawyers who are drafting wills, but there's a number of cases to suggest that the lawyer will not be impermissibly breaching confidence to give evidence about whether the will was actually validly made. So sort of the nature of the competency of the testator and those kinds of issues. This is a difficulty. Wills always raise problems of confidentiality. Okay, so I thought I would move to something slightly lighter for a moment. As I kind of promised, we have another lawyer who's come a cropper associated with assisting Schapelle Corby, and I really apologise for this image, by the way. I'm in no way endorsing anything that's on this image. I just thought it was kind of eye-catching. The lawyer in the middle is Robin Tampo, and this is a discipline case against him in relation to very public disclosure of client confidences and his sort of description. He was very, and he also said on national television that he had concocted the defence in that particular case and received a strong discipline sanction. Now, of course, Justice Atkinson in that case described it as a very emphatic breach of the duty of confidence, of course. Now, there are many other ways in which we may breach client confidence that are far less advertent, and there's just a wealth of advice out there, I'm sure you're all aware, in relation particularly to our kind of use of technology in this space. I've given you a hyperlink to the Law Council precedent, which is quite a good one, I think, about all of that sort of cybersecurity aspect of our practice that we need to observe by nature of being competent lawyers to protect our clients' confidences. The point being that what we must do is take reasonable steps to not inadvertently disclose it. Of course, we shouldn't talk about our client on social media or to a journalist, but also we need to be prudent in the way that we manage our financial, our legal affairs for our clients. One example that seems particularly popular in the ethics world is where documents are sent between lawyers, perhaps in a matter where one document that's electronically, where one document has been subject to a whole lot of revisions, perhaps it's been changed, and then that document has been produced as a final form, but the recipient can mine the information to find out things about the way that that document has been drafted, which might actually be substantive information about the client's position, for example. So we need to be careful about doing those sorts of things in practice. Of course, I don't have time to talk about this, there are now ethical rules that deal with the other side of the coin, as it were, that caution a lawyer from trying to breach another lawyer's confidence. So from trying to snap up an advantage like that and use it against their opposition. Okay, so that's client confidentiality, but there are a number of exceptions to our duty. So we have Rule 9 of the ASCR, which sets out the clear obligation, but then we have a number of exceptions. Now they're very, very limited exceptions, as I'm sure you know. There's one in the barrister's rule. Now the barrister's rules, by the way, may be slightly different around the country, but by and large, the substance is the same. For example, Rule 80 allows the barrister to breach a client's confidences without the client's consent if there is this reasonable ground to suspect that there is a threat to somebody's safety. And then if you turn to the next slide, Rule 9.2 has a number of exceptions associated with breaching a client's confidence to prevent imminent serious physical harm or to avoid the commission of a serious offence. Now, of course, remember that these are forward-looking, they are not backward-looking, so receipt of information about a client having committed a crime, of course, does not fall within these exceptions, but where the client is threatening to commit a crime, a serious criminal offence, then this exception may apply. They are permissive, not mandatory, so it is still up to the lawyer to make an assessment as to whether they think they are covered by the exception and then whether they want to act at all. Let me give you an example of this that comes from a Canadian case, particularly distressing case for a lawyer who was representing, this is Crown and Butt case, was representing a man who was pleading guilty to an offence against a child. He had brought a 12-year-old into his apartment and performed sexual act on the child, received a sentence while they were waiting for an appeal of that particular sentence by the Crown. The lawyer acting for the man found out that he was HIV positive. She was really concerned about his victim having contracted this disease. She took legal advice, as was very prudent of her to do so, and then she took the view that she had to act, and she told the court and the Crown about this. Fortunately, it has a happy ending. The child didn't contract the disease, but obviously it would have been really important to know if in fact he had. Now, I suspect that this is a situation that falls under the exception in 9.2.3, but 2.4, I'm sorry, but there might be situations which are far more questionable, and it shows the really limited exception, the nature of that exception, I think. On the next slide, what I've given you is a just a sort of a checklist that's provided by the Queensland Law Society Ethics Centre. I'm sure there are other forms of this around the country from other ethics, from other law societies. I think it's a really nice checklist to go through that thinks about the way in which the exceptions are worded under the ASCR. The expectation is that the lawyer will really turn their mind to the detail of the issue before them, and to think about whether in fact what the client is saying to them is actually is likely to be a reality, or whether in fact this is not something that is going to eventuate, and this is therefore an unnecessary breach of the client's confidence. What the Ethics Centre also advises, of course, is that it would be really prudent to document this in some way to really justify having made that big call to breach a really fundamental client right. Okay, I'm going on for time, I know, so I'm coming to a close. There are a couple of other limited exceptions that I thought I should just mention for completeness here. As I've already mentioned, I mean, I'm not sure that this one on this slide is really an exception. Rather, it's sort of the bubble of permitted activities under Rule 9. That is, you are still providing client confidentiality ethically if you speak to other lawyers in your practice. It also includes employees in a legal practice. So, of course, non-legal practitioners, but as is necessary to conduct a legal matter, would be perfectly permissible. And of course, disclosure to the insurer is also fine. As I mentioned before, Rule 9.2.3 is a really important one that is relatively new in this notion of the ethical rules. But it's a really great one because it's terribly important that where we have those ethical hard cases and that we start having breached our professional obligations. There are a whole range of sort of specialist services for this around the country. I've given you the senior counsellors URL to the Senior Counsellor Service in Queensland, but there are other ones available around the country. I know Victoria has a hotline that solicitors can ring. It's free and it's totally confidential. As I said, sometimes it might be necessary to seek an ethics ruling. Typically these are non-binding, but they will obviously be very authoritative as to the appropriate attitude to take to. There is this exception in point 2, the potentially huge topic in possibly cover all the ground here. One place that is where a client, for example, has made a complaint against the solicitor. In that case, the solicitor is allowed to defend themselves with a limited disclosure of the confidence in order to defend themselves. But this is absolutely not a free-for-all. This does not mean that the client has absolutely waived all confidential information. That's really important. What's also important, and perhaps it doesn't arise in your practice so much as for small legal practice, so for general private practitioners, but where a client approaches you with an old legal matter and a complaint against a lawyer who might have been working for them before, it's really important to tell the client that if they want to pursue a complaint against that lawyer, either as a civil claim or as a discipline complaint, that they might be waiving their own confidentiality associated with how that lawyer has acted for them in the past, because they probably aren't aware of that, and that might be something they really need to think about. Okay, so there are, of course, a whole lot of required disclosures which are ethically fine to act upon because you are compelled by law. I can't possibly give you all the examples of those, I do note for Queensland practitioners, there is a QLS webinar on search warrants coming up really soon that might be of interest to you if that's something that arises in your practice. The point is that the lawyer is custodian of the client's affairs and needs to be really careful about protecting their confidentiality. So they need to really think about the nature of the demand, whether it is actually authorised under the statute, and of course the documents that are sought are perfectly permissible under that statute. Taking legal advice from the client is a good idea as well, unless that's not permitted under a law. For example, the Crime Corruption Act wouldn't allow that to be the case here. There are very few mandatory reporting requirements imposed upon lawyers at law, as far as I am aware, but you might be able to tell me some other ones that have arisen. In Queensland, under the Child Protection Act, there are no mandatory reporting obligations imposed upon lawyers. There are, of course, imposed on others, except the child advocate. But this does vary around the country, I'm aware, and so you need to be very careful of that, of course. The family law rules don't compel or authorise disclosure, but they do impose upon the lawyer that proactive advising role to make sure that the client understands about their disclosure obligations. So that is a sort of a part of the ethical duty of the lawyers, to make the clients understand that they need to be truthful in those sort of proceedings. So I thought I would just end on this kind of slight twist on this theme, which is the question of confidentiality from our clients. It is generally understood that we need to tell our clients what we know that relates to them and their matter that we're dealing with. But what about situations where, for example, a lawyer knows something that might be particularly distressing to the client, or gets a report from, for example, a psychiatrist about their condition? Can we withhold from our client? I don't actually have an answer to that question. I point you, of course, to Rule 4 about acting in the best interest of the client. There's a little bit of commentary in America, that's ABA refers to the American Bar Association, that suggests that perhaps withholding it, if that's necessary to not distress a client so much that they act against their legal interests, for example. But as far as I'm aware, there's nothing quite like that in Australia, so I'm not sure if that's appropriate or not. But obviously that's something that we need to be aware of, and make sure that we do, generally speaking, give our client the information, notwithstanding that it might be distressing to the client. Okay, I feel like perhaps I've spoken enough, James. Shall I wind it up there and see if there are any questions?
That sounds great, Fran. Thanks for a bit of a whirlwind tour through a whole heap of really relevant stuff, which isn't to say that it wasn't thoughtful and deep, and I appreciate the work that you put into it. Can I remind people that there are a couple of ways that you can ask questions? You can press that button that looks like a hand on the control panel of your GoToWebinar system there, and we can see a hand up here, and we can unmute your microphone. The other way that you can ask a question is to punch it into the questions box on your GoToWebinar control panel. Fran, can I maybe go back 1 or 2 slides there? You talked about the family court rules and the positive obligation on solicitors to inform clients that they should disclose where there's child abuse or neglect. Can I just ask, in practice, my sense would be that the way that advice is provided by a solicitor might be couched in a way that suggests that, you know, here's a box I have to tick, I'm going to tell you this, but you do whatever. Is there anything more positive or more strong that has to happen there?
Well, so I wasn't, so what I was suggesting is, my understanding is for both in relation to financial affairs, disputes associated with financial affairs, you know, it's fairly well established, and there are a number of discipline cases or findings of misconduct by the lawyer at family court, where the lawyer has allowed the client or hasn't alerted the client to disclose, you know, some hidden asset somewhere, for example, which often the client won't be very keen to disclose, of course. but it may also apply to parenting matters as well. It doesn't, so those two don't necessarily connect in the sense that the lawyer doesn't have to, as far as I'm aware, the rules don't specifically refer to the Child Protection Act. Anyway, to your point, not as far as I am aware. I mean, obviously there are very detailed rules associated with the parties' duties in a family matter, which are those procedures associated with disclosing everything relevant to the marriage that needs to be resolved by the court. They're in our ASCR or sort of specific ethic rules, if that's what you're getting at.
Yeah, I guess it kind of goes together, but it's where there is that obligation to provide that advice in that context. To what extent does it need to be, I don't know, forceful or direct or something, right, as opposed to being...
Yeah, I mean, but look, to be honest, you probably need to ask a family lawyer for more family law cases, but as far as I'm aware, there's no content to that in terms of exactly how you would communicate to the client about their obligations.
Sure.
Yeah.
We've had a question roll in, and a reminder, folks, that you can ask questions either by pressing that button that looks like a hand on your control panel or typing it into the questions box, as one of our participants has. And the question that was asked is the advice given by non-lawyers who work under the supervision of a lawyer subject to privilege? Privilege.
Well, yeah, look, this is as I said, that's a huge other can of worms that I didn't quite get. I suspect that it is. So, for example, the case I was talking about is called Aquila and something. So this was about a in-house counsel, I know it's a slightly different situation, but in-house counsel who was a foreign educated and registered lawyer giving advice. And there had been a number of your advice isn't privileged, and then that those had been found to be wrong, and in fact you could be providing legal advice if you didn't have a practicing certificate. And I think properly the thing that we're looking for in privilege is there a legal relationship going on here? Are you providing legal advice to the client for them in impending litigation or to receive advice? So a distinction might be, or are you in fact, say, providing some business advice that wouldn't have that legal? So I suspect my feeling is, and I don't know of a case in relation to, say, a paralegal, but my feeling is the answer would be yes. And of course, remember that advice isn't really coming from that non-lawyer. It's got to be coming from the supervising lawyer, because the non-lawyer is not allowed to provide legal advice, right? That would be a breach of the Legal Profession Act or the Uniform Law. It's a crime for a non-lawyer to provide advice. So if it's been seen and signed off by a practicing lawyer, then that would, I think, naturally be privileged.
What about if it's non-legal advice in a community legal centre?
Yeah.
Then, to kind of draw out Chrissy's example here, Fran, so if we've got a financial counsellor who's subject to their own professional codes under kind of ASIC regulation, but are essentially working under the supervision of the principal lawyer of a community legal centre, providing advice as a financial counsellor to clients on that basis, the confidential information provided by the client to the financial counsellor that's the employee of the community legal centre, would that communication be privileged?
I think the answer is it depends. It could well be, because if it's provided to, so it's either provided to the lawyer or even directly to the counsellor, but in pursuit of seeking legal advice, then that's probably privileged. But financial advice provided back. even if it's sort of attached to legal advice, that may not be subject to legal professional privilege.
Yep. Thank you.
But to be honest, I would like to go and check the authorities to make sure that there's no case law on that particular issue, because there is a lot of case law in this area, because it's of particular concern, I think. And I'd be happy to come back and talk about that in a bit more detail if you like.
You've offered that a couple of times. We'll absolutely take you up on that, Fran. A reminder, folks, you can ask questions by typing them into the questions box or pressing that button that looks like a hand. Fran, you kind of, in a couple of the examples you gave, kind of danced across the issue of media engagement. One of the things that community legal centres from time to time will do will be talk about their clients or give their clients support to talk for themselves through the media about their case and kind of particularly what some of the systemic issues might be. I wonder if in the cases that you were talking about, if there are particular things that we should be mindful of where we're intending to speak to media about a client's experience.
Yeah, so I mean, obviously, things kind of on foot, then that's obviously a danger zone. Certainly if it's I don't know if a barrister might be working in this sector, there are really detailed provisions in the barristers' rules about speaking to the media about a current proceeding. So that's obviously a danger zone, and that would be the case also, of course, for a solicitor, and you don't want to be in any kind of contempt of court associated with speaking about it. Talking about you've acted for, do you mean, James, and you want to talk about sort of it in general terms, these are the sorts of cases that we're seeing.
Exactly right.
Yeah. I mean, I think that if that confidentiality doesn't seem to be it doesn't seem to be a problem if that confidentiality not breached in the sense of the person's identifiable in any way, then that might be a problem. But I think if you were talking in general terms about the types of matters that you were getting, I can't see how that would be relatable to a particular person's matter and a particular person. As far as, I mean, the answer is I can't really recall any cases where that kind of issue has come up, so we haven't got any sort of judicial assistance about the edges of that. But I think it would be unlikely to be a problem unless there was a way for that to, the clients to be identifiable.
Terrific, thanks. One of the questions.
Sorry, having said that, of course, it doesn't fall into that exception of, seeking legal advice. I think that's a very, very limited exception under Rule 9, which is just about, I've got a curly question here, I need to go to an ethics counsellor to ask that advice. It's not a free-for-all to go and talk to the media about it, for example.
Yep. Fran, I suspect some of our participants are treating this as a bit of a generic, let me throw some curly ethics questions at you, which is probably reflected in our next question. Can a lawyer act for the executor in the administration of a estate where that lawyer prepared the will if the validity of the will is in issue?
Oh, well, yeah, look, so have a look at that non-binding ethics ruling that I sent along as well. I think the issue there is going to be about potentially being a witness in the case, and obviously that's a concern. So there are ethical rules that, well, they used to simply prohibit a lawyer from continuing to act if they're likely to be a witness in a case, but now there is a provision in the rules, that this is Rule 27, that allows someone else in the practice to continue on with the matter, but it's that's a very dangerous ground, I think, that you're sort of travelling along. So that will probably be the concern there. Having said that, if all the lawyer has done is they've executed it and they're holding it, they've drafted it and they're holding it for the client, or even I suspect if can't see that that's a huge problem.
Yep, terrific, thank you. We have just ticked over past 2 o'clock, so I might draw the line there. Can I, on behalf of people clapping and cheering wildly at computer screens across the country, Fran, thank you for that presentation, and thank you for going to do multiple presentations in the future. We'll absolutely take you up on that. It was a really exploration of a whole heap of complex issues that come up every day in community legal centres, and I think that sentiment's being echoed by some of the sending through messages. Thanks everybody who tuned in and participated. We hope to have a recording made available in the next little while, and hope to speak to you soon. Thanks everyone, and goodbye.